We were invited by the Cook Islands in 1989 to draft the first of its kind asset protection specific legislation. And it was kind of an interesting exercise because we were doing this work using the Isle of Man at the time, and it really gave my law partner then and I, and then the New Zealand barrister that invited us in this effort, gave us a chance to sit back and say, okay, so where are the holes in what we're doing using the Isle of Man, and how can we patch those statutorily? And it was kind of fun. And I think today we've seen not only that it has the most thorough and protective law, but that it also has among the best trustees qualified to do this sort of work, because there are many, so you need both. You need the good law and you need the trustee company. And I've seen other trustee companies that are very happy to take the annual fee for acting as trustee, but as soon as the finger is pointed at them, they buckle. And that's not what you want to have happen. So you need a trustee that can stick out its chest and thump it, and you also need a jurisdiction with good, protective, thorough law to support the concept. All right, anything else? Thank you. Yes?
The conspiracy to defraud the United States, I've seen them use that broadly, claiming they were concealing, trying to cover something up as you're going along. They claim that they're entitled to know things, and that by preventing them from knowing things, that's conspiracy to defraud them. I guess also, we were talking about the reports that you're required to file. I've seen where there's more than one that wasn't filed, sometimes they'll throw that onto the indictment also.
Right.
They're claiming they were entitled to have that information, and you defrauded them of the information.
Well, I guess I'll repeat the essence of what you say for the tape. I think if the government is your adversary, first of all, they've got unlimited resources. They've got all sorts of statutory provisions they can throw in. And sure, they're going to throw in 55 counts, and you might end up settling for one count of, conspiracy to interfere with the judicial system. Sure, of course. But, we all do it. I mean, if I'm sending a demand letter to an adversary saying, this happened to my client, and they suffered this, and they said, I'm going to start out with, I demand $55 million in cash delivered to my office tomorrow, and then maybe we'll get some money one day. I mean, I'm exaggerating, but you can expect that, absolutely. You can expect the overcharging, as you put it.
And after the Anderson case, has there been any more significant developments in this area?
Yes, quite a few. The comment was, after the Anderson case, have there been any more significant developments in this area? And the Anderson case, for those of you that don't know, is probably the first real challenge to one of these sorts of things that involved the settlors of the trust actually going to jail for contempt of court. And the mistake that the Andersons made was they set in motion what made it impossible for them to perform after they were ordered to repatriate assets. So, of course, they were held in contempt of court. But it's the first case that people tend to bring up when they say, oh, gee, I thought this concept died with the Anderson case. Well, no, in fact, it's very much alive. And since Anderson, there's probably been another 10 or 12 cases of note. I've written extensively on the concept of does this work and so on and so on, and I have some of that in my outline that I can send off to you. I'll just mention to you in terms of does this work, the frame of reference is it's not an absolute victory or not. What we're looking for is when it's all said and done, did the client come out better than the client otherwise would have had there been no planning in place? I mean, that's the realistic goal. And in every case where the client followed protocol and we were involved in the challenge, we met and surpassed that goal, and I've had over 100 challenges over the years. That's a big number. It's a small percentage of cases. It's probably 8% or so of the plans we've done, but that 8% translates into over 100 challenges, and that's where the rubber meets the road in this work. Not when somebody says, here's your asset protection trust, thank you very much, where's my fee? It's when 3 years later they call and say, I got a problem, who should I talk with? That's where the rubber meets the road. And the standard there is, when it's all said and done, did they come out better than they otherwise would have by at least a moderate level or degree? I think we're overdue. Thank you for your kind attention, ladies and gentlemen. I enjoyed talking with you. Thank you.